Hey crew, this is Cassidy. Normally when I get one of these, I wait till I hear from the other side and then I have both documents to compare. But this time I wanted to do just a really quick opinion piece, not an official legal update, but just a brief my opinion of these things, because some of the talk I've heard out there is just out of control. One of those things being the differences between the application of the Remmer case versus the State versus Green. I will explain those two cases, what they were about, and why that's important. The Remmer case was decided 70 years ago in 1954. State versus Green, 4 years ago in 2020. It's also important to understand what those cases were about, because Dick likes to use little bits that are from that decision, but I'll tell you why I don't think they apply to this. And it's the same reason why when Dick kept bringing it up to Justice Toal during the evidentiary hearing, she finally said, "I don't think that means what you think it means." So let's find out why she said that, and some of the other things in this brief. And of course, I'll do a longer one once I have State's reply. Let's get started. The worst part of what I do here is deal with documents written by Team Alex. Seriously, it's painful. Similar to Dick's performance in court, when he couldn't convince with skill and logic, he resorted to getting loud, insulting, or throwing tantrums. In writing his briefs, which are rarely brief, he resorts to wearing you down with words. They're repetitious, dramatic, full of exaggerations, and even outright falsehoods. So when I saw this appeal is 132 pages long, I printed it, read the table of contents, and went to bed to deal with it another day. Repeating the same point a million times over does not make it true, and it irritates rather than convinces, in my opinion. There are pages and pages and pages about Becky Hill. These arguments have been used over and over again, and though they've gotten him nowhere, here they are again. It covers pages 19 to 71. That's 52 pages. Most of the things in this brief we've discussed here extensively already, and 132 pages, it's just too long to cover the entire thing, so we're going to cover this with the table of contents as a guide instead of all these rambling pages, and we'll go into certain pages as we get there. I'll put a link to a copy of this brief so that if any of you want to download it and read it for yourselves, you're more than welcome to do that, but we're going to hit the main claims. Part 1 starts by the dramatic exaggeration that a state official was secretly advocating a guilty verdict. The meaning of the word advocate is to support or argue for or to plead in favor of. Even the accusation made by Juror Z does not meet this definition. That's why I call it a dramatic exaggeration. And as I've said, and as I'll say today and will want to say over and over, this was not found to be the case by Justice Toal. And when we talk about Justice Toal, we're not talking about your average judge. She is the former Chief Justice. She literally set legal precedents for decades. She also served alongside Justice Kittredge, who decided and authored State versus Green. Now, I don't presume to be smarter than her or better versed in the law as so many out there have done by criticizing her decision. If the Supreme Court overrules her, that will be that. But these Joe Schmoes, most of whom haven't spent a day in law school, saying that she's mistaken, or these lesser attorneys who would never, ever qualify for her seat in the Supreme Court, truly have no right saying she's wrong. Because what they're saying is that they're smarter than she is, and that they're better qualified to make this decision than she is. And it's ridiculous. He goes even further to say that Justice Toal's decision is unsupported by and contrary to the evidence on record. This is simply not true. And after pages of a fictitious rendition of Juror Z's affidavit and testimony fiasco, he's so bold as to say this on page 31. He says that she denied the motion for a new trial by committing legal error and by abusing her discretion, because in this document, the court is her. He goes on with the ramblings of Becky Hill advocating for a guilty verdict, and then says, because, so Justice Toal denied this motion, committed legal error, abused her discretion, because, in her opinion, the correct verdict was rendered regardless. Do you understand the importance of this accusation? He's saying that because Justice Toal agreed with the verdict, that that's the reason that she, in his opinion, committed legal error, abused her discretion. That's a big accusation to make. Basically calling her dirty. And now this line. Despite a juror's uncontradicted testimony that her verdict was affected. Sir, this juror contradicted herself. She under oath gave her verdict. Then she answered the poll. She never said a word about anything like this happening until, in her own words, Alex's lawyers told her what Becky did wasn't right.
Well, whenever his lawyers had come to me and explained some things, it didn't all click until they had, talked to me and to let me know, what Becky did wasn't right.
So would you have ever come forward if the lawyers hadn't come to find you and tell you that Becky had done something wrong?
Probably not.
Even after that, the best they could get her to sign an affidavit for was saying that she was pressured by other jurors, something that cannot be used to overturn a verdict, and something that the rest of the jurors say never happened in the first place. Well, that affidavit wasn't going to be good enough, so after more coaching, she says something completely different on the stand, but she can't even manage to keep that straight. She gets all confused, all twisted. Justice Toal observes it, calls her on it, dismisses her. Then Dick was in a panic. That was his golden goose. So he fights with Justice Toal about it, trying to get her another go at getting the script right this time. But that's not allowed. You don't get do-overs like that. So Justice Toal denied it, and he threw a fit, and he's still throwing a fit, something that he already knew was not proper court procedure that he's demanding, and you better believe if this was something the other side was asking to do, he would be screaming his head off objecting to it. He knows it's wrong, but he's still going to demand it, and he's still going to write about it like he was done wrong. Now, as he continued to press her about this, he got her to say what would be needed in a new affidavit. And who can forget the exchanged looks between him and Joe as if to say, hey, did you get that? And then moments later, Joe turns up with a whole new affidavit to fit Justice Toal's criteria. How convenient. And then this little excerpt from an earlier podcast of mine, we find another issue, rumored to have been written about unfavorably by Becky in her book, and becoming angered by it, the alternate, who didn't even deliberate on the case, came forward to complain and also testified at the hearing. It really feels like a grudge club, with the most mysterious part being why did Joe immediately represent Egg Juror? She had no legal action taken against her. She had no legal recourse to take action against anyone else. She was there before the book. She was there before anyone spoke out. It doesn't match the timeline they've tried to put out. This alternate, yes, but something was already brewing before she joined the Grudge Club. But then they needed an actual deliberating juror, and that's where Z came in. But Joe's presence through all of this is the most questionable of all. I do note that this witness was a bit testy on the stand, and her affidavit was rewritten and signed just the morning of this hearing, which was very suspicious to me. She also didn't seem super familiar with the contents of it. Just like Juror Z, her affidavit was written with extra information to better suit the requirements by Justice Toal on the 16th. Remember that look exchanged between Dick and Juror Z's attorney? Look at that little smirk on his face. And watch him turn around, and who does he look at?
Information was improperly brought to the jury's attention, or whether any outside influence.
And furthermore, if Juror Z was so influenced by what she claims Becky said to her, why did she go into deliberations thinking that Alex wasn't guilty and have to be pressured, in her words, by other jurors to put not guilty? Doesn't that show that she was, in fact, not influenced by what she alleges Becky said to her? It's looking more and more like some kind of plan to guarantee Alex a new trial that somebody somewhere cooked up. and nobody can keep their story straight. She gave her verdict. Then she said the other jurors pressured her. Then she said Becky Hill pressured her. Then she took it back and said the other jurors pressured her. Then she signs a whole new affidavit saying it was Becky after all, and wants another go. And he says her testimony's uncontradicted, and that Justice Toal, for not finding this woman credible, was abusing her power to save the verdict that she thought was right? The only abuser of power in that courtroom was Alex when he stole money from his vulnerable clients. Justice Toal saw an unreliable witness in her courtroom. The testimony was all over the place. She made the correct legal decision in all of her wisdom. But while we're talking about Joe, his involvement in this whole thing stinks to high heaven. According to witnesses who were in trial in person multiple days, sitting near him, and they can be seen on court TV to verify this, he was there with a badge and a reserved seat. When he was asked why, he said because he represented Connor, and Connor had been accused of committing the murders. Was he simply there for his client? Especially for his client's good. Because he was observed leaking gossip and passing notes to reporters. He was also heard loudly making remarks about the trial. At one point, saying to the person behind him, "What an idiot." Who was he talking about? John Metters, attorney for the prosecution. First of all, this from the guy who can't file an appeal correctly. Second of all, was he there to support Alex all along? Does this sound like an attorney who's there for his client who has a case against Alex? And he sure pounced on the egg juror immediately after she was dismissed. Which I'll always find odd, because what on earth does a dismissed juror need an attorney for? And why was it okay for him to do this if by his admission he was representing Connor against Alex? How is he representing a client against Alex and another one for Alex at the same time? And I wonder if Connor knew about this. Because Connor fired Corey for his close relationship with Alex. So why would Joe take this case? Joe, who's good friends with Dick. Is this even ethical? But lastly, he was observed flirting with the younger women in the courtroom. Yeah, cringe alert. And something else I want to say about this accusation that Becky was advocating for a guilty verdict. He loves bringing up the book and saying that in order for the book to succeed, there had to be a guilty verdict. What absolute and complete nonsense. Let's talk about that. When there's a trial and everybody is happy with the outcome, we're pleased, we forget about it, we go on. It doesn't stand out. When there is a controversial verdict, you better believe that's what gets attention. This case gets compared a lot to the O.J. Simpson case. O.J. was not found guilty. Sometime, do a search to see how many books were written about O.J. Simpson getting away with murder. And then look up and see how many of those books sold. It's outrageous. A controversial verdict is always better than the one that just pleases everyone. Becky could have sold 10 times the number of books she sold if he had not been found guilty. I promise you that. Completely overriding her decision, he goes on to say, prejudice was proven at the evidentiary hearing. Which hearing was that, Dick? The one in your head? Because not the one we saw. And of course, then there are pages and pages about Remmer. You know, the case Jim calls Remmer. Let's talk about this, hopefully for the last time, because we've talked about it so many times. And people repeat this over and over and have probably never read the actual case to understand why Justice Toal did not use it as the standard. Now, you guys send me stuff from time to time, and I appreciate it. And what I saw today, coincidentally, while I was reviewing this appeal in the first place, was one of the irky things that have ever irked me. It was a clip of someone that they said is a lawyer. I don't know this person, never watched this person. But this person said to their audience that Green was about a juror asking a bailiff when the pizza's coming, or something like that, she said. I couldn't believe it. So inaccurate and so irresponsible to put that out there to people who will just believe it and repeat it and spread the falsehoods that are rampant on these streets. If you don't know something, don't be proud. Look it up. Make sure that to the best of your ability, you've tried to present accurate information. Stating opinions on something is okay. We all have opinions. I'm all about my opinions here. But stating something so factually wrong and misleading is not an opinion. It's a whole different situation. And when people are looking up to you as a source of information, that's a responsibility. Let's talk about these cases. Remmer is what Dick is demanding that they use, and State versus Green is what Justice Toal used. Justice Toal called Remmer outdated, and according to the citations in the government's replies to Alex's old motion for a new trial, many courts have agreed with that it is not the standard any longer. Now let's compare these cases. In the Remmer case, an unnamed person communicated with the juror who becomes the jury foreman. This person tells this jury foreperson that he could profit by bringing in a verdict favorable to the petitioner. This is a straight-up bribe. This is an unnamed person, not the clerk of court, not a bailiff. The juror reports this to the judge, who reports it to the prosecuting attorneys, and they meet. As a result, the FBI actually makes an investigation and a report. This is seen and known only to the judge and the prosecutors. So while this case is going on, this is happening and nothing further is said or done. Defense finds this out after the verdict is read. Please tell me, what part of this case has even the slightest resemblance to Alex's trial? An outsider bribes a juror, the juror tells the judge tells prosecution but not defense. It goes as far as being investigated by the FBI, and defense finds out after the verdict. There is not one detail in here that has the slightest resemblance to Alex's trial. That's why it wasn't used. State versus Green. This is the more modern case. This was tried in the South Carolina Supreme Court by Justice Toal's colleagues, by the way. This is the one she uses. Now, what's this one about? At some point during active deliberations, the most sacred part of the whole trial, a juror asks the bailiff what will happen if the jury is not able to reach a verdict. The bailiff answers that the judge would give them an Allen charge and send them back to deliberate longer. Now, this is court staff speaking about something that could possibly affect the verdict. How? This invokes fear of displeasing a judge. Lets them know the judge is not going to accept this. He's going to give you a stern talking to, a stern charge, and say, get back in there and get this decided. Okay? Much higher level than a clerk of court. And it's also kind of a threat that deliberations could drag on if they can't decide. No juror wants to sit there and deliberate for days on end, or even hours on end. This definitely could have affected them to try to hurry up and avoid displeasing the judge and avoid getting stuck there longer. They could have seen it as, we can't possibly disagree. He's just going to send us back if we disagree. But still, even in this situation, the South Carolina Supreme Court trusted the jurors who had been given a very important job to do, that they could make a decision with their big boy and their big girl minds. Why are we acting like these are children who are not capable of making a decision based on facts? In an interview with me, one of the jurors, Amy, said that everywhere she went during the trial, people were talking about the trial. It was unavoidable. If she were in the grocery store, if she were getting nails done, people around her were talking about it. And this is the case with most juries today. Very few juries are sequestered these days. So are we supposed to believe that none of the juries are able to bring good verdicts because they just melt away if they hear the wrong thing? The respect that Justice Toal gave them as intelligent human beings who were capable of making intelligent decisions based on the evidence, which is what they're there for, that's the respect that Justice Toal gave them. She believed in them that they took their oaths seriously. And what's important in this ruling is that the court recognized that the bailiff's conduct was improper. It's stated in the decision. They say, although the bailiff's conduct was improper. So they didn't say that what he did was okay. They acknowledged it, but still said that it had not affected the verdict after polling the jury. Now, Alex's case doesn't come anywhere close to being like Remmer, with actual bribery, money offered the foreperson, with prosecution and judge being aware of yet concealing from the defendant, and letting the jury decide a verdict without defense's knowledge. It's not the same at all, but Dick likes to pick out a few words from the court's decision and use those to dramatically label Alex's situation as jury tampering. When you look at these two cases, Alex's is so much more like State versus Green. Next, we get to the financial crimes, him saying that they should have been excluded. Now, of course, we have to keep in mind that this is exactly what defense attorneys do. Long before trial, they're doing this. They try to exclude every bit of testimony that's going to show their client's guilt. We expect to see this. But just because they say it in a brief or have motions heard in court to try to exclude this evidence doesn't mean that that's the right thing to do. Jim tried to paint the day as just any normal, ordinary day that Alex was fine, Alex was happy, but there's no way he was fine. There's no way he was happy. He'd been caught at work that very day. He knew exactly where that was going to lead, or at least the potential of where it was going to lead. Maggie had been already asking him about finances. She'd had a check bounce. She was just getting started on remodeling her beach house in Edisto. And by the way, she was spending most of her time there, effectively leaving Alex alone at Moselle. The boat crash had a hearing coming up in 3 days, and he knew that he was not only going to lose his job, but his law license, and that his dad was dying and unable to help him anymore. This was arguably the worst day of Alex's life. He was about to lose everything. These are the moments people make wild decisions, do crazy things. This was Alex's state of mind. Now in Part A1, he calls the prosecution's motive to distract illogical. But motive doesn't even belong on this brief. You know why? Because motive, although it's helpful to prosecution, it is not a criminal element required to find someone's guilt. It's simply not. The state doesn't have to prove motive. I personally don't fully agree that the motive was distraction. I think it was like almost every other case of femicide. It's brought about by the loss of power and control. Maggie was one of women according to statistics, and if you follow me, you know these statistics already. She was one of the women that is killed every 10 minutes by a partner, an ex-partner, or a family member on this earth. Or one of 3 women killed every day in this country alone by a partner or an ex-partner. And Alex was a man backed in a corner, about to lose his very identity by losing his place in this legacy, messing up this legacy, and with it, all of his power and control. That's where Alex's mind was that night. And point 2, I beg to differ that any probative value of the evidence concerning the alleged prior bad acts was substantially outweighed by the unfair prejudice that resulted to the defendant. Therefore, it should have been precluded. I couldn't disagree more. It wasn't just to show that Alex was a thief. That would have been prejudicial and unnecessary. This was Alex's mind in that moment, and therefore it makes points 3 and 4 moot. Then they have the nerve to address his post-Miranda silence. And do you know what part of testimony that hinges on? They say that they used his post-Miranda silence to impeach the exculpatory trial testimony that Alex offered about being at the kennels in violation of Alex's due process rights. His lies about the kennels. This is in here because they want to appeal this case. They want to retry this case. This was the evidence all the jurors have said was the moment they knew Alex was guilty. They want this out, not just for this, but for the future. They don't want this allowed in court again later. And so to do that, they're going to stretch stuff here. They say that it would have been precluded from this line of questioning if Murdaugh had claimed his right to silence from the beginning and had kept silent throughout. Woulda, coulda, shoulda. He didn't. And then they misapply Doyle here. They say, a defendant's due process rights are violated when a prosecutor seeks to impeach a defendant's exculpatory story told for the first time at trial by cross-examining the defendant about his failure to have told the story after receiving Miranda warnings at the time of his arrest. Now, what was shown in court to disprove his lie about the kennels were videos that were already admitted in evidence. Some of them had already been shown. The statements were made before he was arrested for the murders. There was no need for a Miranda warning when he sat in the car with these agents and talked to them, or sat in their offices and talked to them. He wasn't under arrest. He was telling the court why he lied about the kennels, and the state used evidence already admitted, some of it had been shared, to show that that wasn't true, and questioned him about it. There are boundaries to Doyle, and though they claim Judge Newman made an error when he ruled that Doyle was not in play here, let's see if that's true. Doyle is about not being allowed to make the defendant look guilty and impeaching him because of his silence. That silence is a right and cannot be held against you later when you've used that right up until court. They can't use the silence to impeach you or insinuate guilt just on the basis of your silence. We've all heard in court a judge will instruct the jury in a trial where defense did not testify that the jury cannot assume guilt because of that silence. It's along those same lines. But here with Alex, we have a specific situation. Alex had given multiple statements to the police at a time when he was not a suspect in the murder. Those are in evidence. The jury's already seen them at this point. But let's go on. He was giving a statement of what happened to his family. He was not under arrest. He was not in cuffs, therefore not Mirandized. and it was months later that he was even arrested for the murder. By then, he had been interviewed multiple times, and his multiple statements were not truthful, and that's important. He's being questioned here about why he lied in those statements. Here's an example of one of the boundaries, one of the exceptions to Doyle. U.S. versus Gant from 1994. It concludes that the reason for an arrestee's post-Miranda silence is usually insolubly ambiguous. A defendant may open the door to impeachment with silence by his own remarks about his post-arrest behavior or by defense counsel's questioning. The only limit here is that they can't argue that that silence is inconsistent with the claim of innocence. Now they're talking about when Creighton was cross-examining Alex. So he's being cross-examined, which means he's already been questioned by his own team, and that was Jim Griffin. The first thing Jim asks him is whether or not he killed Maggie and Paul, and of course he said no. The very next question was Jim asking Alex if that was his voice at the kennels, and was he there? Jim then asks why Alex lied, and Alex gives his reasons for why he lied. Now in this case, where had this defendant messed up? It was about his credibility, because he had claimed that he had been cooperative with police, portraying himself as a law-abiding citizen. Mr. Gant impeached himself by his own remarks about what his behavior had been like during this time and his interactions with the police. These were not true. By testifying falsely about his behavior and blaming the police, he opened it up. Now let's compare this to Alex. First of all, Alex's own lawyer opens up this line of questioning by asking him why he lied. Secondly, Alex blames his behavior on law enforcement. He talks about them testing his hands for gun residue. He says that he thought the agent was a different law enforcement officer who had harassed his friend, in his opinion. This is testimony about Alex's behavior, and it was opened by defense and Alex himself. Another thing that happened in this trial was that in closing arguments, defense counsel fully presented the theme that he had developed throughout the trial, that the government had abused its power and pursued Mr. Gant to get another conviction. He argued that the government's witnesses were unreliable, and he portrayed Mr. Gant as a law-abiding citizen who was against the use of drugs and who was needlessly harassed by the police. You could almost put Alex's name in here, and it would be the same story. It's that similar. Dick and Jim made the same mistakes in Alex's trial as were made in this one. Both Alex and his counsel erred in opening the door, therefore waiving the Doyle standard. And it's so funny to me that they put this in print, saying Judge Newman is the one who erred, when this Supreme Court ruling disagrees. There is no doubt Jim Griffin opened this door wide open. And this is certainly not the only such case. Here's a short list of some other exceptions. Now let's watch that moment in Alex's trial and tell me what you think.
Mr. Murdaugh, is that you? On the kennel video at 8:44 p.m. on June 7th, the night Maggie and Paul were murdered.
It is.
Were you in fact at the kennels at 8:44 p.m. on the night Maggie and Paul were murdered?
I was.
Did you lie to Sled Agent Owen and Deputy Laura Rutland on the night of June 7th and told them that you stayed at the house after dinner?
I did lie to them.
Did you lie to Agent Owen and Agent Croft on the follow-up interview on June 10th that the last time you saw Maggie and Paul was at dinner?
I did lie to them.
And in the interview of August 11th, did you tell Agent Owen and Agent Croft, did you lie to them by telling them that you were not down at the kennels on that night?
Yes.
Alec, why did you lie to Agent Owen, Agent Croft, and Deputy Rutland about the last time you saw Maggie and Paul?
As my addiction evolved over time, I would get in these situations or circumstances where I would get paranoid thinking. It could be anything that triggered it. It might be a look somebody gave me. It might be a reaction somebody had to something I did. It might be a policeman following me in a car. That night, June 7th, after finding Mags and Paul, don't talk to anybody without Danny with you. All my partners were just repeatedly telling me that. I had a deputy sheriff taking gunshot test from my hands. I'm sitting in a police car with David Owen asking me about my relationship with my wife and my son. And all those things coupled together after finding them, coupled with my distrust for SLED, caused me to have paranoid thoughts.
But you surely can't blame defense for trying to get it out. Now, Part D, they make the claim that allowing the state to introduce multiple guns that were seized from the Murdaugh residence when no evidence linked the guns to the murders. My first question, do you mean the gun you pointed at the prosecution table, sir? Is that the gun you're talking about? But secondly, the guns were in fact used in testimony, particularly amongst Paul's friends who had actually seen, held, and shot Murdaugh weapons, and could identify the types of weapons that they owned. Remember, guns were missing. They testified about Paul having lost his gun and replacing his gun. Shots were fired not long before the murder, and they left key evidence in this trial. These guns were very important, and that's why they want them gone. The testimony given about Paul having a replacement gun also prevented Alex from being able to say that Paul had just lost another gun and that's why it was missing. So we can definitely see why Dick is against this evidence. Lastly, we have the blue raincoat. Now, a witness, and a credible witness, testified to seeing Alex carry something like a blue tarp upstairs. The raincoat was tested. It had residue. It became a piece of evidence. Now, defense had their chance to discredit it, like every other piece of evidence. There's also talk about Alex's clothing. A big deal is made about how they said it was presumptive for blood, but when it tested, it was just tiny little spatters. Sir, there's still missing clothes that Alex was wearing earlier in the day before he got all cleaned up. Everyone knows the clothes that Alex was wearing that night were freshly put on before he went to his mother's. And the fact that there's so little blood residue on them does not help the case, because Alex claims that upon coming upon the bodies of his wife and son, if he were truly, absolutely unaware that he was going to find their dead bodies, we would expect him to be covered in blood. He claims that he checked to see if they were alive. The clothes are more suspicious that they don't have blood all over them. But anyway, this is what defense has to do. This isn't just about this appeal. This is about, if they get a chance to try this case again, getting the court the next time around to exclude these most important pieces of evidence to create a situation where prosecution cannot make a case. That's what you have to remember about this document. That a lot of the stuff in here is simply not true, not factual, exaggerated, and outrageous insults made, this time not just against the clerk of court, but against the former Chief Justice of the South Carolina Supreme Court. Now, the state has 30 days from December 10th, which was the date of this filing, for them to give their reply. The court has a mountain of evidence to sift through. The court transcripts alone are overwhelming, then the multiple cited cases in these as well, and then whatever cases the state responds with. So there probably won't be a super quick response by the South Carolina Supreme Court, but I will be here waiting for those updates to share with you, my lovely crew. Till then, this is an aggravated Cassidy O'Connell saying stay well and stay tuned.